Hi, I'm James Minick, and today we're going to talk about the necessity defense in the context of a DWI charge. This is an affirmative defense to the crime of driving while impaired, as well as other crimes, and so we're going to go through the elements of that defense. There are a number of different factual situations where a necessity defense might be appropriate in the context of a DWI. A medical emergency, fleeing from a dangerous situation or a violent situation, or even responding to a vehicle's mechanical failure. In the necessity defense realm, I normally don't like to start legal arguments off with a public policy rationale in terms of talking to specifically a judge, but even in regards to a jury. You typically want to begin with the black and white letter of the law. With the necessity defense, it appears particularly appropriate to begin with a public policy explanation of why the defense exists. And this is taken from a case, State versus Thomas. Quote, "The rationale behind the defense is based upon the public policy that the law ought to promote the achievement of higher values at the expense of lesser values, and that sometimes the greater good for society will be accomplished by violating the literal language of the criminal law. If the harm which will result from compliance with the law is greater than that which will result from violation of it, a person is justified in violating it." This appears to be kind of the same public policy rationale for civil disobedience in terms of violating laws for basically a higher reason, a higher value. The elements of the necessity defense, which the defendant must prove to the satisfaction of the jury, are three. One, that the defendant took reasonable action. Two, that action was taken to protect the life, limb, or health of a person. And finally, number three, that there were no other choices available. With regards to element number one, reasonable action, again, we see in criminal jurisprudence, once again, the touchstone of reasonableness in our argument. And I think that there are a number of factors that could be looked at to determine whether the action that was taken was reasonable, whether your client is making a split-second decision, the availability of calling 911 or other appropriate emergency personnel, the seriousness of the threat, defendant's military, employment, educational, or other relevant background or training, and the state of mind of a person facing similar circumstances as the defendant is in. Reasonableness at the end of the day depends on circumstances. So this is something that can be argued in terms of what creates the reasonableness in this particular situation. Element number two, basically the action can't be taken to protect property, but outside of that, the threshold appears to be pretty low in terms of protecting a human, because basically it's protecting the life, limb, or health of a person. So I think that's a relatively low threshold, and again, in terms of higher values versus lower values, protection of life should be really at the forefront of our legal justice system. In terms of the final element, this appears to be really where the crux of the argument is in most of the necessity defense situations, because the defendant also need proof that there was no other acceptable choices available. And this is, to some extent, the prosecution's opportunity to argue all of the different ways that the person could have avoided the action that they ultimately took. And typically in the DWI context, that action would be driving, right? I mean, the question is typically not impairment. It's a matter of why did person get behind the wheel of the vehicle and drive. And so, again, in terms of establishing this element of no other acceptable choices, the state is going to come up with potentially hundreds of different reasons why this wasn't the only acceptable choice. The thought process, I think, that in conveying to a judge really should be to look at the situation, the factual situation, and explain the circumstances as the defendant was seeing them at the time. Generally, this is a situation where somebody's kind of acting under high pressure with limited ability to kind of think about what all of the different options are and to kind of go line by line through how to take appropriate action. Really, the question is this the best alternative for the defendant? It's not phrased in that way. It's phrased as, was there any other acceptable choice? But looking at it in the context of the particular situation that the defendant is involved in, it really does come down in some way to what other options were available and assessing those other options as being reasonable, rational alternatives to driving the vehicle, and try to put the judge or jury into the shoes of your client. The courts have recently talked about, in several cases, the dissipation of the necessity defense. So in a context where the necessity defense actually exists, there can be a time, the courts have said, when the defense basically dissipates. So I think in one of the cases, State versus Batson, the court said, without some testimony to support a conclusion that defendant drove only as far as necessary to get out of harm's way and seek help, defendant has failed to meet his burden. So if you initially are driving out of a true necessity, but then basically continue to drive on your way home for a 30-minute period, the courts have looked at that and said, when does the necessity defense dissipate? When is the defendant out of harm's way? So be ready to argue that point. The burden of proving the defense, again, is on the defendant to the jury's satisfaction. This is a little bit of an odd defense because it's not one of the defenses currently listed in the discovery statutes in terms of needing to put the prosecution on notice as to establishing this particular defense. It may be wise to go ahead and provide notice of intent to use the necessity defense out of an abundance of caution, but it might be strategically better as well to not inform the prosecution of that until trial. And currently the discovery statute does not seem to require that, even upon request for disclosure of certain defenses, because necessity is not listed as one of the defenses subject to disclosure under General Statute 15A-905C1. The only other thing, and again, this is a little bit odd in regards to this particular defense versus most other affirmative defenses, is that there really is no pattern jury instruction for the defense of necessity. And where there is no pattern jury instruction for that, the judge certainly has to advise the jury as to the law. But because there's no pattern, somebody, either the judge, you, prosecution, or otherwise, is going to have to craft a jury instruction for the jury. And this provides an opportunity, if you have prepared a instruction in writing, it is probably much more likely that your instruction would be utilized than the judge's own or the prosecution's, because the judge is not going to want to have to do more work than is required in order to give his instruction. So if you have a proposed jury instruction, particularly where there is no pattern jury instruction, you're much more likely to have that given by the judge to the jury. In our blog article, we have taken some legal points from a recent case of State versus Miller, as well as a combination of other cases, and a comparison to the jury instruction on duress and coercion, and crafted a jury instruction that I think is a accurate reflection of the law, and that is available on our blog on the necessity defense in the DWI context.